my friend, from my petitioner side. Now, the allocation of the portfolio would not have any discretionary power of the Chief Justice. But that doesn't preclude him to take up the matter since he has heard the matter. So it is a duty to point out, although the Lordship has the right to proceed the matter, but it's a duty as an officer of the court to apprise the status of the case. That is the thing. We're not disputing his allocation. But there is a factual thing that transpires in the record. So,
it is not that, my lord, the acting Chief Justice has heard it and some other Chief Justice has transferred the matter. It is he only who has transferred this matter before this honorable court. I don't know what is the difficulty for the learned seniors to argue this matter before this honorable court.
No, I have no difficulty.
Then we can hear it, my lord. We'll hear it.
My lord, this is a matter of propriety, my lord. Propriety demands, my lord, this is to be pointed out, this is to be placed before the Chief Justice. Nothing. It's a matter of propriety. I have no problem arguing this case before this court.
So let us argue it. My lord, since he has no problem,
I have no problem, but the matter of propriety demands, your lordship.
We'll take up this matter on Friday.
Friday, my lord, it will be difficult, my lord. Let it come after puja then, my lord.
In the meantime, what I'll do is I'll try to check up the administrative order in this respect.
My lord. Friday, my lord, it will be difficult.
In fact, my lord, it will happen, but generally it has been. There are two other matters, my lord. Hearing concluded. Somehow I think it has escaped the notice of the Honorable Chief Justice, my lord. That's how this confusion happened. And it's not the question that I am reluctant to do it before my lords. I will feel privileged to do it before my lord.
Let us do
but
it.
the propriety demands, my lord, these things are to be pointed
We'll take it
out.
up on next day.
My lord. After puja, my lord. On 6th, my lord. Let it be fixed on 6th, my lord. 6th of October, my lord.
on the 10th, if Lordship permits, 10 or 11.
Okay, my lord, I have no problem. Let it fix on.
This will be the first reopening.
Then let it be on 10th, my lord. 11 it cannot be because it's Saturday.
We'll have
10th.
it on 11.
Let it be on 10th, my lord.
Mr. Sen?
My lord, I have no problem, lord. Whatever your lordship decides.
On 10th, my lord. Hello.
On premade parties, this is matter on 10.
My lord.
Lovely.
May it please your lordship. Your lordship, I beg to mention item number 15 and 16, your lordship. Lordship, I'm praying for some time, lordship, in this matter.
Have you seek consent of the other side? Yes, Mr. Chanda? Unmute your microphone. It's not audible. Who's the his?
Lordship, I've informed his assisting counsel. I've already informed his assisting counsel.
'24. On premade by Miss Landed Counsel for the respondent, seeking accommodation for the day. That is adjourned. This is him after 2 weeks.
Much obliged. May it please your lordship, I beg to mention item number 10, your lordship. Item number 10. Bring this, let this matter come up after puja vacation, your lordship.
I am appearing on behalf of the respondent number 3, MITC.
Okay. On premade by petitioner, this is matter after 2 weeks.
Please, Your Lordship. Lordship, I beg to make a mention of item 4. Item 4, Your Lordship.
I think 4 and 5 are connected matters. This matter has been heard substantially.
Lordship, praying that the matter may come about.
Petitioner has been heard, yeah.
Lordship.
In fact, I think as far as your part is concerned, I think that is done. If I'm not mistaken, I may be wrong.
On the last occasion, a prayer was made by my friend that he wants to refresh Lordship's memory, my lord.
Oh.
Lordship, after puja vacation, Your Lordship.
Why is it 2019 matter? I don't think we'll. So make sure you do it.
Lordship,
You refresh the court's memory.
Lordship, after vacation, Your Lordship.
Why vacation? Why? We do it today. Matter has been listed time and again. If you go to the order sheet, you will find this. So many times accommodation has been allowed to you. Cannot go on like this. Now, see, we have reached a situation where the matter has been heard maybe 2 weeks ago, 3 weeks ago, 1 month ago, and the matter has been, the court has forgotten the facts or the law or whatever has been argued before the court. And now, see, if you refresh me, you're practically going back, restating your whole argument. So if we go on like this, then matter will not end.
Lordship, kindly let.
Yet again, Mr. Letter Counsel petitioner has sought for accommodation on grounds of personal difficulty. It is reiterated that this matter is an old pending case which requires to be heard expeditiously. On preamble, the prayers allowed, it is made clear that no further adjournment will be given in this matter. List this thing after 2 weeks.
Lordship, in item 5, I'm in second matter, Your Lordship.
Since these are analogous matters,
Oh, 5.
they may be listed together. My lord.
So 5, so list this matter after 2 weeks.
All right, my lord.
Highly obliged, Lordship.
May it please Your Lordship. Your Lordship, I beg to mention item number 17. Your Lordship, I'm praying for 2 weeks' time.
On premier by the appellant, list this matter after 3 weeks.
Prepare, Lordship.
Lordship, right, Lordship.
From daily list, item number 1.
Yes.
Yes, my lordship, I am appearing for the respondent number 1, 2, and 3. Today is the first day, my lordship.
1, 2, and 3.
Yes, my lordship.
How many respondents are there?
3, your lordship.
Okay, you are paying for all the respondents?
Yes, my lordship.
So paperwork is required to be.
No, your lordship, but records will be called, your lordship, because evidence and exhibits will be needed.
Records have not been called.
No, your lordship.
But the appeal has been admitted. Has the appeal been admitted?
No, your lordship.
Or not yet?
Just but interim stays there, your lordship.
Ms. G. Purkhasta, Letter Counsel, has submitted that she is entering appearance on behalf of all the respondents. The appellants have, the appellant insurance company has approached this court being aggrieved by the judgment dated 23/5/2025 passed by the learned member, Motor Accident Claim Tribunal, East Coast District, Shillong, in MAC case number 12 of 2014. It is prayed that there are good grounds for appeal against the said impugned judgment, and accordingly this appeal may be admitted. So we'll admit the appeal. Ms. Professor has no objection to the prayer made, and submission made. Accordingly, this court is also inclined to admit this appeal. The same is done so herein. The record from the tribunal is hereby called for. On receipt of the said record, the appellant is directed to prepare an informal paperwork. This is matter after 3 weeks.
Lordship, once more, interim stay may continue, Lordship.
In the meantime, the interim order passed by this court, dated 22/8/2025, in MAC Appeal number 4 of 2025, will remain in force until further orders.
Item number 2.
Please, Your Lordship. Lordship, I pray for some time to file a rejoinder in this affidavit, Lordship.
You filed the counter affidavit?
Yes, Your Lordship. We filed a counter affidavit as well as an additional affidavit to bring on record the status report, Your Lordship. So both have been filed.
Mr. Learned Counsel for the petitioner has sought for time to file the rejoinder to the counter affidavit as well as the additional affidavit filed by the state respondent. Pray aloud, this is matter of 3 weeks.
Obliged, Your Lordship.
Item number 3.
Legal aid?
No, my lord, the record was supposed to be called. This matter was.
You're appearing as legal aid?
Legal aid.
My lord, if I make a prayer, my lord, if we can have this matter at the end of the board, my lord. Mr. Sen is on legs before court number 2, my lord. However, it is...
Your Lordships have already heard Mr. Sen in reply on the last occasion. It's for me to give my short reply and rejoinder. So, my lord, you can start, my lord. Learned friend is here. She can
That
take
is my difficulty. Otherwise, my lord, we have no objection. My senior friend can advance his argument, my lord.
I can start, my lord, if your Lordships is...
Well, it depends if you
because if it becomes necessary for Mr. Sen
if you feel handicapped, with Mr. Sen not being here.
Yes, because
Then, my lord, we can have it after the occasions, my lord. Because I have some other matters in the other benches also, my lord.
Okay. Okay. Pre-made by parties, this is matter after vacation.
Deeply.
Item number 7.
My lord, this is the part heard matter, and the petitioners have already completed their argument also. The other sides, respondents had taken time to verify the document. They conclude their argument. That is in that same court number 2. So, at this stage, that is on 26, 24/6 of 2025. That's the order. So, order dated 24/6.
See, this is the problem. Now, this matter has been listed for the first time here.
Yes.
So this court, has no occasion to hear you. So you have to start from. The beginning. You may say that your argument is already completed,
yes.
But that is not before this court.
Yes.
So what do you propose?
I think for early disposal of case, they should be transferred to court number 2 so that it can be disposed earlier. So at this stage, we have completed our argument. A file of written argument also.
No, had it been, recorded as part heard, then
part heard.
It is not so.
Order 24.
Order 24/6 just recorded your argument being completed,
yes.
And the respondent to respond. Nothing is said that matter is to be kept part heard. That is the difficulty.
So,
and
I can call you
more often than not, this court will not propriety demands that not every case has to be returned back. So you can start then.
I can start if my lord, in this case, actually, the fact is the petitioner got a work order on the basis of the tender floated by the state of PWD, and being the lowest bidder, I got the work order from that department, PWD, Meghalaya State. And thereafter, I started the work. I completed the work with full satisfaction, and I handed over the work to the state PWD department, and it's the duty of the PWD, state PWD, to prepare the bill, and it's sent to the regional transport authority, Guwahati, central government, so that they are the paying authority. But duty of the state PWD is to complete the bill after proper verification of the work contract completed by the petitioner. So thereafter they verified, and they partly released the payment, and subsequently some portion they have not verified, not passed the bill, final bill. The final bill is pending, and after going thorough, regular pursuing the matter regularly, but no action has been initiated by the state PWD, and no final bill is passed, approved, and sent to the central authority for disbursement of payment. This is my grievance, my lord. And there is no dispute in this matter. There is no dispute on record.
As far as your your grievance is concerned, is there no alternative forum?
Yeah.
Is there any alternative? You see whether you can approach this court, or you have to go by way of a civil suit, or
no, I have not civil suit. Directly I come being aggrieved by the inaction of the state PWD. I filed this writ petition because PWD is the government authority. And Central Ministry of Transport Authority also government authority, central authority. So this court is jurisdiction under Article 226, and this matter already have been discussed before the other court. So this is also this court has jurisdiction to interfere in the matter. My grievance is they have to disburse by the unpaid balance amount of this in contract. They have not complied with their obligation, contractual. They have violated the contractual obligation in the case. This is my grievance.
Okay.
So I have filed during the argument also on the other side they have raised that this Article 226 cannot be invoked at this stage because this is not maintainable, all these things.
Okay.
I have filed in my written objection. The Supreme Court said citations. This matter is no more res integra as on that. This is a settled law. In spite of that, there is an alternate remedy or alternate remedies there. Also, when there is illegality, when there is a inaction or arbitrariness in the proceeding by the state government or state authority. So in this case, Article 226 can be invoked. This court, honorable court, has a jurisdiction. So that has been also I have filed. So my only grievance is I have not paid my legitimate dues, which is already outstanding since long. So that should be disbursed. This should be after passing the fine order bill by the state authority. This is the case here. So I have already filed in the written file along with these citations also attached. In this case, my liabilities I am entitled to receive the amount 4 crores 90 lakhs 94,964 rupees. And there is no dispute raised by the departmental authority in connection with the quality of the contract project or quantity of the project or in relation to any other, nothing, but only their inaction is the problem here.
Where is your impugn representation or letter?
My lord, at page number 94, in the compilation written argument, I have compiled all the evidences filed by others, both sides, from the petitioner side as well as from the respondent side. At page number 94.
94 of what?
Compilation in written argument.
Page 94.
94. Issued by the Government of Meghalaya, Office of the Chief Engineer, PWD Roads, Bridge and Division Plans, to the Director General Roads Development, Minister of Shipping and Roads and so and so, Pariyavaram, New Delhi. Kind Intensive Chief Engineer so and so, subject revised estimate for reconstruction of bridge number 166/5, balance work inclusive bridge number 166/4 within the approach along with the approach and so and so. With reference to the subject I cited above, I have the honor to submit here with the estimate for the above mentioned work amounting to rupees 7 crore 96 lakhs 84,106, duly approved by the undersigned for favor according to the revised administrative approval. 2 numbers of estimates are enclosed herewith for favor of necessary approval. And then come with 95. Again the PWD writes to the Director General Roads. With reference to the subject above, I have the honor to submit herewith the revised estimate the above mentioned works for 754. Of these 4 only, approved the additional Chief Engineer West Zone, Tura, for favor of your kind approval and early sanction. These are sanction has been sent to the central government authority, but bills has not been completed. Current bills has been only provisional bills has been some portion is released in my favor, and the final bill has not been completed. because the sanction is pending. So no action has been initiated from the state authority. This is the inaction caused by here, by the department. So I am depriving my legitimate dues since a long period.
So tell me, what is the procedure that is required to be to be followed in this?
Here actually I completed my project. I handed over to the department. Department will verify.
So after completion of your project, you file your report.
Yes, I filed. Department came and verified.
Where is that?
Verification completion, no? Yeah. So they
issued me running bills.
running bills कहाँ पर है? My lord, page number 49, they have issued the running bill, CC 6. Here, they prepared the bill up to 6. The 7 is, we have filed our estimation, but 7 is pending. They have not prepared the final bill. Final will be the 7. Here they have 1 crore 60 lakhs 38 they have issued, calculated the amount. Thereafter, if they make the payment out of this bill, they have released my payment at page number 63. At page number 63, annexure 3, and
is page 49
page
is
number 63.
No, page 49 is the part payment.
Yes, Papa. Then this is the detail of the payment which they have issued to me. At page number 63, they are writing to Ministry of Transport and Highways, Regional Office Guwahati. They are writing to the Executive Engineer. This is a reference to your letter number so and so dated 15/3/2023 regarding details of the expenditure for the above mentioned project. In this regard, a confirmed form of account register of regional pay and accounts officer NH Guwahati. The details of payment made to Sri Upendra Shah for the above mentioned work is enclosed. However, the details of vouchers for the same is not available in this office, because this is a duty of the state authority to prepare the voucher and send to the state central authority, so that central authority will disburse the payment. So in 64, the pay and accounts officer, he is giving a serial number, bill number, RA number 1, bill value, amount paid.
Okay.
At 64.
Yes.
And 64 bill RA1, RA2, running account 3, running account 4, running account 5, running account 6. Total bill value 4 crore 38 47 396. Out of this, 3 crore 96 99 089 has been released, disbursed by the central unit authority to me, and remaining what is the final bill is not prepared by the state authority, so that's why they are unable to reimburse the payment. This is the situation, I know.
And according to your calculation, the final bill comes to
4 crores. I have already calculated at page number 3 of this compilation, 4 crore 90 lakhs 94,964 in the compilation, page number 3. under which account I am entitled to get that amount, outstanding amount. Differential amount withhold 74 lakhs 51 on final bill number CC7, and cost of escalation bill 71 lakh 25 up to RA bill number 6, cost of escalation bill up to June 2013 67 lakh 7887, 8% security deposit deducted from my bill, which is I am entitled to get, because at the time of payment of bill.
This amount, have you made a demand for this amount?
Yes.
Is there any objection?
No objection.
No objection.
No objection. Nothing. As on date, they have raised no objection on these bills. They are keeping silent.
Where is your demand for this?
Yes. Demand हम क्या था ना, regular payment. Demand हुआ था ना इसमें. थाना डिमांड नोटिस. My lord, demand notice I have filed, submitted. Reminder number 1, 2, 3. At page number starts from 11. 17 reminders has been issued, my lord.
Page 11.
Page 11. In compilation, annex mark is annexure 2.
This is the first.
First bill. 23rd March 2021.
That's from 2009.
नहीं पास में दिया था ना कौन सा है 21 से दिया है ना रिमाइंडर 1. ठीक है तो पहले इसे नोट करा देते हैं. यहाँ से स्टार्ट हुआ है ना
71. So your demand here is 2 crores.
हाँ 2 crores. Some time to time whenever due payment getting due, security deposit, then of escalation bill and estimation earnest money. For after completion of 6 months, they will hold up this amount. Thereafter, they will release the amount. So whenever time passing on, I am raising my bill time to time, and accordingly 17 reminders appears from time to time. I have demanded here. So first in demand is 23 to 21. Registered ID to the Chief Engineer, National Highway, PW Roads, Meghalaya, Shillong. Here, withdrawal, withheld amount from RA bill CC7, 7451. Price variation bill, 71 lakhs 25. Price variation bill, 6770. Security deposit, 35. On this date, I claim this. Thereafter, I again.
There's no response to this?
No response, nothing. I have going on filing a reminders, and they are kept silent. No response, no demand, no dispute, nothing.
Yes.
Thereafter, second reminder also, first reminder said 24 October 2014. First, thereafter, second reminder 12 February 2015. 8 crore 87 lakhs.
First reminder.
Page 17.
Reminder.
Page 15, 16 and 17.
Okay.
Here I have also mentioned in the last paragraph, is page number 17. Nearly 2.5 years to completed the to be completed since the last payment has been made by the department, and no sign of any payment nor sanction of the revised estimate has been found for non-receipt of any their payment of for such big amount, and nonetheless non-release of the amount kept within the RA bill number 6 of 74,51,500 even after a lapse of more than 30 months has enforced by me to suffer the acute financial hardships besides the burden to recover the bank interest. My lord, actually here this is the I have taken loan from the bank. I have completed this. I have to pay time to time the bank interest also. But this is the type of inaction by the I am suffering my working capital also wiped out in this due time because I have to pay interest here. There I am staying without any. 2009. Since 2009, I am giving the reminders. It comes to 2017, 15, 16, 17 numbers are reminders, but they are kept silent in the prayer. At page 39, in 2009, the first reminder letter was sent to the respondent. Yes. Page number 39.
First reminder, this is first reminder?
Yes, this is first 6 September 2009. The first letter was sent. Thereafter, subsequently, 17 reminders were issued.
No, I don't. Okay.
This is in reverse way.
See,
reverse
first reminder you said 6
September 2009 at page number 39.
What about then 24/10/2014? This is also first reminder.
This is in the middle, in the between. Actually, in the reverse way that has been filed. Reverse order that is filed. First is page 39. Second is page number 38. At 22 of June 2009. Another one. Payment of extra work. Then 26 June 2009. Then again to 14, 15, 19 that is coming over.
So that is only your case?
Yes.
May it please your Lordship. Lordship, my first contention is done. This petition is not maintainable, your Lordship, because what happened, your Lordship? It involved disputed question of facts. And it is also a monsoon in the sky. There is no admission on the part of the respondent regarding the amount payable to the writ petitioner. Lordship, why a writ petition has been filed, Lordship, because Lordship, there is a legal bar under the law of limitation, your Lordship. Because what happened, your Lordship, I kindly have at page 28, your Lordship, of the writ petition. Lordship has seen the compilation, your Lordship. Lordship has seen page 38. Can you see page 38, 39, your Lordship? Demand of money, your Lordship. Demand of money was raised sometime in the year 2009. Then Lordship, for the time being, if Lordship kindly leave aside the note of argument, kindly come to the writ petition.
Yes.
Lordship, kindly have page 28. Kindly have page 28, Your Lordship. The demand was made after a period of 6 years, Your Lordship, in the year 2014, Your Lordship. When did the writ petition file? The writ petition was filed in the year 2022, Your Lordship. Lordship, if Lordship kindly have the law of limitation.
Section 3.
Lordship, if Lordship kindly have.
Okay.
Lordship kindly have the schedule. If Lordship kindly come to page 13 of the law of limitation, that is scheduled at clause part 18, Your Lordship. Lordship, kindly have the schedule, the period of limitation, first division suit.
First division suits, yes.
Lordship, kindly have clause 18. For the price of work done by the plaintiff for the defendant at his request, where no time has been fixed for payment, 3 years when the work is done. So it is the admitted fact, Your Lordship, that the work was done in the year 2008. Then Lordship 113. Lordship, kindly have 113.
Yes, just a moment.
Lordship, kindly have clause 113. Lordship, yes. Any suit for which no period of limitation is provided elsewhere in the schedule, 3 years. 3 years. That is why, Your Lordship, to avoid the law of limitation, instead of filing a suit or instead of going for arbitration, Your Lordship, there is a contract agreement, Your Lordship. I'll show Your Lordship. So this writ petition has been filed. That is why, Lordship, my first concern is not maintainable. It's not maintainable. Lordship, then kindly come to the writ petition. Lordship, what is the prayer made in the writ petition? Lordship, first I'll come to the maintainability, then I'll come to the merits, Your Lordship. Lordship, kindly have Annex 1 at page 10.
Yes.
This is the agreement, Your Lordship. Then Lordship, kindly have page 12. That is the general rule. Then Lordship, kindly come to page 14. Page 14, Your Lordship. Lordship, that is the tender for work that are costing 4,87,30,500. Lordship, this tender work is part and parcel of the tender agreement, Your Lordship. Conveniently, Your Lordship, conveniently the writ petitioner has chosen not to enclose everything, Your Lordship. Lordship, I do have. This is the agreement, Your Lordship, signed by the writ petitioner. Lordship, I have flag mark, Your Lordship. There is a clause for arbitration. That is the flag mark, Your Lordship. Exactly, Your Lordship. This document were never annexed, Your Lordship, when the writ petition was filed, Your Lordship. There is a clause for arbitration, Your Lordship.
But see, generally in contract matters, arbitration clause is always
Lordship, yes. That is why, Lordship, I made a submission. Conveniently, the writ petitioner has chosen not to enclose everything, Your Lordship. That means withholding all these vital documents, Your Lordship, which amount, in my humble and respectful submission, Your Lordship, material suppression of facts.
Yes.
And to that, Your Lordship, I would like to rely on the judgment of the Honorable Supreme Court, Your Lordship. Yes. If Lordship kindly have para 18 of that judgment. This is 2021-10 SCC, page 690. Lordship kindly have para
10.
Para 18, Your Lordship.
18.
Para 18. That internal page 702, Your Lordship. Lordship has got him.
Yes.
Lordship kindly see. Mr. Natara has also placed reliance on the judgment of this court reported in so and so, wherein the following was held. Law in this aspect has developed through a catena of this judgment of this court, and from the reading of this judgment, it would follow that in pure contractual matters, the extraordinary remedy of writ under Article 226 or Article 32 of the Constitution cannot be invoked. However, in a limited sphere where such remedies are available only when the non-government contract party is able to, that is a public law remedy which such party seeks to invoke in contradistinction to the private law remedy simply under the contract, some of the cases to bring home this cardinal principle is taken note. On this basis of this fact, this court observed that the aforesaid observation of the High Court relying on so and so, this finding in our view is in the light of the fact of the case, because in so and so there was no concluded contract in this case. Even considering that it has a trapping of the state, it would be comprehended in other authority for the purpose of Article 12 of the Constitution, while determining the price of the house flat buy-in and the rate of monthly installment to be paid. The authority or its agent, after entering into the field of ordinary contract, act purely in its extreme capacity. Therefore, are no longer governed by the constitutional provision, but by the legally valid contract, which determine the rights and obligations of the parties inter se. Then, Lordship, kindly see closed para 39 of the judgment, Your Lordship. At page 703, Your Lordship.
743.
Lordship, yes, para 69 is a continuation, Your Lordship. The position, same page, Your Lordship. The position does summarize. Lordship has got it.
Yes, yes.
The position does summarize in the aforesaid principle has to be understood in the context of discussion that preceded, which we have pointed out above. As per this, no doubt there is no absolute bar to the maintainability of the writ petition even in contractual matter or where there are disputed question of fact or even when money claim is raised. At the same time, discretion lies with the High Court, which under certain circumstances it can refuse to exercise. It also follows that under the following circumstances, normally the court would not exercise such a the court may not the issue unless the action has some public law character attached to it. Whenever a particular mode of settlement of dispute, kindly see, Your Lordship, is provided in the contract, the High Court would refuse to exercise its discretion under Article 226 of the Constitution and relegate the party to the set mode of settlement, partly when the settlement of dispute is to be restricted to through the mean of arbitration. Then, Lordship, kindly come to para. Then, Lordship, in the same para 69.3, Lordship, if there are various disputed question of facts which are of complex of nature and require oral evidence for their determination. money claim per se, particular arising of contractual, are normally not to be entertained except in exceptional circumstances. So, Your Lordship, in my humble aspect, this judgment of the Honorable Supreme Court would be squarely applicable in the present case, Your Lordship. Then, Lordship, kindly come to page para 24, Your Lordship. Para 24, Your Lordship. Therefore, the dispute could not be raised by way of repetition on the disputed question of facts, though the adjudication of the High Court is wide, but in respect of pure contractual matters in the field of private law, having no statutory flavor, are better adjudicated upon by the forum agreed to by the parties. Lordship, here in this case, Your Lordship, there is a signed agreement between the authority of the state and the writ petitioner, where in case of any dispute, Your Lordship, then it will have to be restarted by means of arbitration as laid down in clause, Lordship, or clause 3, Your Lordship, of that of which I have handed over to Your Lordship, are better adjudicated by the forum agreed to by the parties. The dispute as to whether the amount payable, Lordship, kindly see, payable or not, and how much amount is payable are disputed question of facts. Therefore, there is no admission on the part of the appellant to interfere that amount stand crystallized. Lordship, here as I have submitted, Your Lordship, there is no admission on the part of the respondent that this is the money, this is the amount payable to the writ petitioner. There is no such admission, Your Lordship. That I'll come later on, Your Lordship. Therefore, in the absence of any acceptance of joint survey or report, but there no right would accrue to the writ petitioner merely because measurement cannot be under. So, Your Lordship, as I have submitted, there is no admission. Now, coming to the merits, Your Lordship, of the case. Lordship, kindly come to page 8, Your Lordship. That is the relief claim in the writ petition. Lordship, the relief claim in the writ petition is for the outstanding amount of 4,08,30,688, Your Lordship. Then, Lordship, kindly come to page 28.
Yes.
Here, the request for release of this amount, Your Lordship, was raised in the year 2014.
Yes.
Then there is a continuation, Your Lordship, at page 29. Representation after representation, Your Lordship. Then at page 31, Your Lordship. At page 33, Your Lordship. At page 33, Your Lordship. In the first request, Your Lordship, there is a mention of 74 lakhs. Then, Your Lordship, in the second representation, Your Lordship, at page 29, there is a mention of 6 final bill of 6 crores, Your Lordship.
6 crores 61.
6 crores 61, Your Lordship. Then, Lordship, kindly. Then in page 31 also the same amount, Your Lordship. In page 33 also reminder 2 also same amount, Your Lordship. In page 35 a reminder 3 also same amount, Your Lordship. And then at page 37 at reminder 4 also same amount, Your Lordship.
Yes.
Then at page 39 reminder 5, Your Lordship. At page 39, Your Lordship.
Yes. Yes. Page 39, yes.
Lordship, yes. Page 39 also, Your Lordship. Same amount, Your Lordship. Yes, same amount. Now, Lordship, I take Lordship, to the written argument filed by the writ petitioner. Lordship, kindly have page 11. Kindly have page 11. Where is our exhibit? This one. What is that? 6. Wait, just a minute. Lordship, kindly come to page 11 of that notes, Your Lordship. Lordship, kindly see at 4. Lordship has seen that 2, Your Lordship, which has been pointed out by the writ petitioner. Lordship, kindly see 4. Despite the lapse, kindly see, Your Lordship, more than 6 long years, the department has not yet prepared the final bill for which I have completed long back. As per the revised estimate, final bill amount will be rupees 1 crore 41 lakhs. Lordship, kindly see.
Yes.
In the writ petition, there is a demand of 4 crores. Your Lordship, in this demand in 2021, Lordship, it is stated that 1 crore 41 lakhs. Then Lordship, kindly come to page 64. Lordship, kindly come from page 63.
Yes.
This is the letter, Your Lordship. This also has been enclosed by the state, Your Lordship, in our affidavit. Lordship, this is the letter issued by the Assistant Executive Engineer for Regional Officer Civil Guwahati, that is a Ministry of Government of India, Lordship, to the Executive Engineer. Lordship, kindly come to page 64. Lordship, kindly come to close to serial number 6.
6.
Bill, Lordship, kindly, that is the bill amount of so and so 85 86 74, then check number so and so. This is the one now. Lordship, kindly see that bill RA6. Then Lordship, kindly turn back to page 11. The particular of bills, Your Lordship. Lordship, kindly see at serial number 1.
Yes.
Serial number RA bill CC into rupees 7451 556 556, Your Lordship. So there is a difference, Your Lordship. Which is the amount, Your Lordship? That is, Your Lordship. That is why I made a submission, Your Lordship, that it involves disputed facts, Your Lordship. There is no admission on the part of the respondent, Your Lordship, as I have submitted, Your Lordship, that this is the amount payable to the writ petitioner. There is nothing as such, Your Lordship. There is no admission on our part, Your Lordship. Then, Lordship, kindly come. What is that? 64. agree, Your Lordship. Then, Lordship, kindly have our affidavit. Lordship, kindly have para 8 of our affidavit at page 4. This is the affidavit filed by the Chief Engineer. Lordship, kindly have at page 4, paragraph.
Affidavit dated?
This is dated, Your Lordship, we filed on 9/6/23, Your Lordship.
9/6/20.
Lordship, yes. Lordship, kindly have para 8. Because what happened, Your Lordship, this is the central project, Your Lordship. The money is paid by the government of India and it is being implemented by the state, Your Lordship, through the Public Works Department.
Yes.
Lordship, if I may read, Your Lordship, that the answering dependent state that with regard to the letter of the so-and-so requesting the ministry to furnish with regard to the factum of payment to the writ petitioner was received from the Assistant Executive Engineer for Regional Office Ministry of Road Transport and Highway Government of India by letter. In the said letter against the bill number so-and-so, 30 so-and-so are submitted by the answering department, the ministry confirmed to have paid an amount of so-and-so. 3,96,99,089, Your Lordship.
Yes. This amount has been paid.
Lordship, yes. This is the letter, Your Lordship. Lordship will find it at page 11, Annex 3 of our affidavit. In their compilation also, Your Lordship, I have drawn Your Lordship attention to that. This is also will find at page 63, Your Lordship, of the compilation submitted by them, Your Lordship. Annex 3 at page 63. This is borrowed, Your Lordship. This in compilation, this one at page 63, Your Lordship, which they have compiled, Your Lordship, this they have borrowed from our affidavit, Your Lordship. So to conclude, Your Lordship, my contention is that this writ petition is not maintainable, Your Lordship. It is, as I have submitted, Your Lordship, it is a money suit in disguise, Your Lordship, because there is a delay, Your Lordship. There is a delay, Your Lordship, because the law of limitation provide, Your Lordship, so far a claim of money suit, Your Lordship, the period is 3 years as per the law of limitation. Admittedly, Your Lordship, in the writ petition, dispute was raised in the year 2009, in 2014, and the writ petition was filed in the year 2022, Your Lordship. That also after a certain period of years, Your Lordship. Then, Your Lordship, conveniently, as I have submitted, Your Lordship, the tender agreement has been annexed in the writ petition, but the writ petitioner has chosen not to place the complete agreement before Your Lordship, because in the said agreement, as I have pointed out, Your Lordship, there is a clause for arbitration, Your Lordship. If any dispute, Your Lordship, it has to be resolved by means of arbitration, Your Lordship. So, to that, Your Lordship, I have placed, Your Lordship, that judgment, which in my humble and respectful submission, Your Lordship, is squarely covered this case. So, my humble and respectful submission, Your Lordship, and the writ petition, Your Lordship, is liable to be rejected, Your Lordship. That is all, Your Lordship.
My Lord, in response to their submissions for the complete my landed friend, actually they have suppressed the material facts before Lordship. That whenever a tender was executed, I got the tender, I complete my responsibility from my side. I have handed over the project to the department. It's the duty and responsibility of the state PWD to complete the billing process. Billing after proper measurement in the site and after considering the all terms and conditions of the agreement, contract agreement, it is the responsibility of the state PWD to complete the bills. Whenever my payments are releasing, it is the RA bill, running account bill. So that means in phase wise, complete project is completing and phase wise I am getting my payment or by a running bill. That is called RA bill, 1, 2, 3, 4, 5, 6. When I handed over the project, it is the responsibility of the PWD authority to complete the project bill, final bill, to approve the final bill, and that final bill should be referred to the central authority for disbursement of payment. My learned friend is not clear this matter. It is a responsibility of the PWD authority. And they have to do. I cannot file the bill. I cannot mention submit the bill. I cannot make demand. It is their responsibility. They will complete all these things. And there is no dispute from the central authority. Time and again, central authority are telling that you send your approval bill, vouchers and everything. No response. Now, it is the responsibility of the department to act fairly, and as a government instrumental having sovereign authority, it is the responsibility of the department, government authority, to completely as a fairness. So, whenever there is in absence of fairness in their working or performance, in that case, Article 226 can invoke. This is a settled law. When there is a violation of principle of natural justice, when there is a arbitrariness, here in this case, they are kept silent. They are not preparing any bill, nothing. They will not pay. So, if that is the situation in the country, no contract will come forward to complete that in time. So, it is a go against the policy of the government. The government should not do in this way. So, it is the responsibility of the government authority or governmental authority or a department to play fairly.
See, the point is this. Okay, let's consider it logically. Forget about the running bill, running account bill. That is done. You've been receiving it from time to time.
Yes.
For 6 times. When the final bill, rather when you have completed the work, who has to prepare the final bill?
State authority, PWD authority.
Okay. If they prepare the final bill,
no.
Let's put it.
Yes.
If they are to prepare the final bill,
yes.
So it has to be intimated to you.
Yes.
That has not been done.
Not done. Okay. That's why I'm deciding.
Then, if that is not done,
yes.
Then how did you know what is the amount that is due to you?
Yes, from time to time, whenever there is as per the terms of the contract agreement, I am entitled for the escalation bill. So time to time, whenever this is getting due, I am submitting my bills.
That we are not talking about the running
that
bill.
is not actually appropriate proper bill.
No, we are not talking about the running bill. Talking about the final bill now.
Yes.
If you say that, you see, if I can understand, your final bill now with interest and everything or escalation will come to 4 crores something. How did you determine that amount? When you say that they are supposed to, to inform you that this is the amount that is due to you.
Yes.
They have not done so.
Yes.
If the department has not done so, how did you come to know of this?
As per the contract agreement, as per the works agreement, what is the value of the contract was 7 crore. That was
87 lakhs.
No, 7 crore 54 lakhs 53,000. That was the estimated revised estimate. My lord, here I have already mentioned here at page number 75. Page number 75, annexure P3. It is a categorical in 2018. Project is completed in 2008, 9, 10, and it has been 18. The department is writing to the authority, please refer to your letter data submitted here with a revised estimate. In 2018, they are making the correspondence for revised estimate for approval. Then only my payment will be released. Final will be prepared on that. They have not sending any approval to the central authority. In 2018, my learned friends telling about limitation.
That is the point. See, now, what you are implying is this: since no amount has been cited by the department as far as the final bill is concerned, so you have made your own calculation.
Yes. This is my own calculation as per the terms of this agreement.
Exactly.
Measurement of this.
Exactly.
Yes. I have calculated and submitted.
So you have calculated and submitted.
Yes.
That is the point.
We have submitted to the executive engineer, not to the paying authority.
Exactly. You have submitted that final bill.
Yes.
And they have failed to respond to that.
Yes. They have failed.
That is your contention.
Yes. If anything is to be disputed, everything, they let me complete the final bill. Then only will come to our notice. Then we will make no, this is the condition, this is the condition, this is my dues, that is to be payable, this is not payable. Nothing that they are keeping idle. And in 2018, they are making correspondence. My land friend is stating Limitation Act, where Limitation is not applicable in Article 226. For invoking Article 226, Limitation Act is not applicable. I have citations. I will submit.
We are not talking about. He is not citing Limitation Act is only with regard to your right. Rather,
Yes. When
your obligation to file a civil suit at that point of time.
Fine. But here in 2018, there is a correspondence between the department and all these things, and my landed is a limitation here. There is no question of limitation at this stage, because they have not doing their correspondence is continuing, is still continuing. My humble suggestion is that let them prepare the final bill and ascertain the payment and send to the central authority, so that my payment will be disbursed at the earliest, so that I am facing financial crisis, bank liabilities there, I am paying interest to that. So I have prayed before Lordship to pay the interest also. And here my landed friend has stated regarding the arbitration clause. Although there is an arbitration clause, the Honorable Supreme Court has settled. In that case also, the Reed Court has the jurisdiction to interfere in the matter when there is illegality. And
what of course.
There. So my whatever I have submitted in
principle of judicial review will still apply.
Compilation I have submitted this case law citation that is available here, and here also in 2018 Supreme Court, this also says there is a judicial revision and all these things. Whenever there is also illegality. At B, Constitution of India, Article 2, writ judicial, contractual disputes involving public law interest are amenable to writ jurisdiction at para number 10. And second also C, Constitution of India, Article 14. There also there is a directly violation of Article 14. And D, Constitution of India, Article 2, writ court power of the review. While considering the said jurisdiction, it is not only as a court of law, but is as a court of equity. A clear error of omission on the part of the court to consider a.
You are reading which?
D para is the 5 in the editorial. Para number.
Go to the relevant para.
Para number relevant para 17.
17. Just a moment.
Article 14 of the Constitution of India has received.
Just a moment. 17.
Yes.
Yes, Article 14.
Article 14 of the Constitution has received a bilateral interpretation over the years. This scope has also been expanded by creative interpretation of the court. The law has developed in the field to a great extent. In this case, no dispute in question of fact is involved. We do not thus find any substance in the Constitution.
Mr. Sorry, I did not get your name.
My lord?
I could not get your name. What's your name? I could not get your name.
Your name. My name is Sahu, D. Sahu.
Okay, Mr. Sahu.
Yes.
See, again, if you read that para 17, it says no disputed question of fact is involved.
Yes.
But
in this case, there is no dispute of fact.
In this case, it is the contention of the.
There is no dispute.
No, is their contention that there are disputed question of facts.
There is no pleading, there is no evidence on pleading, my lord. There is no dispute here. Okay, anything disputed, so I would reply to that. I have make conciliation, everything can be possible. But unless and until there is a dispute, how can I interfere in that? For conciliation proceeding. There is nothing. Here there is no dispute. Otherwise, I would not come here. I have to settle with the arbitration proceeding, because there is no scope here at this stage. Because they are keeping silent. To whom I will appraise? Where I will go? They are keeping silent. The central authority, they also, you have nothing, we are the paying authority, unless and until that will come from you who are helpless. Here they are sleeping, without any action. So where I will go? How I will approach the civil court? Because there is no dispute here. So, regarding invocation of Article 226, these cases are so many. I have cited in case number also here in my compilation. At page number 2 page 96. There is a Karnataka High Court judgment in 2024. At page number 96, a state authority must act in the compilation
Page 93.
96. After discussing all these settled laws by the Supreme Court, the Karnataka High Court in 2024, they make pass the order a state.
Para?
Yeah, in the editorial state first line, a state.
Which
page number 96. Head note. Editorial note. A state entity must act in accordance with the principle of fairness and justice in contractual obligations.
You should not refer to head notes.
No, I am coming to the paragraph.
Head notes are comments.
Yes,
by
comments.
editor.
I am coming to the my lord. At page para 26. As para 26 at page number 104, it's a therefore this objection at page number 104. Paragraph 26. Therefore, this objection must fail because in a given case it is open to the writ court to give such monetary relief also. From the above discussions of ours, the following legal principles emerges as to the maintainability of writ petition. A. In an appropriate case, a writ petition urged against a state or an instrumentality of a state arising out of a contractual obligation is maintainable.
Yes.
B. Merely because some disputed question of fact arises for consideration, same cannot be ground to refuse to entertain a writ petition in all cases as a matter of rule. But my friend, even there is a dispute also, that cannot be. A writ petition involving the consequential relief of a monetary claim is also maintainable. See. However, while entertaining an objection of the maintainability of the writ petition under Article 226, the Constitution of India, the court should bear in mind the fact that the power to issue prerogative to writ under Article 226 of the Constitution is plenary in nature and is not limited by any other provisions of the Constitution. The High Court, having regard to the fact of the case, has a discretion to entertain or not to entertain a writ petition. The court has imposed upon itself certain restrictions in the excess of the power, as said Whirlpool Corporation was the register of trademark. Here in the there are so many guidelines passed by the Honorable Supreme Court in the Constitution bench. When there is a violation of principle of natural justice, all these things that has been discussed here. Thereafter, in the order form in the last at page number 11, I think that the order, the writ petition is allowed. A mandamus is issued on the respondent to release the amount of 5.52 crores to the petitioner with a period of 4 weeks from the date of receipt of the copy of the. In the event of the amount could not be released within the 4 weeks, so the interest will be charged. So here that is admitted in my case, which is squarely applicable in my case. Secondly, when there is an arbitration clause, this is also settled law by the Supreme Court. I have cited here in my compilation. Although there is an arbitration clause, the Honorable Court has the jurisdiction to enter it to when there is illegality and to the fairliness is not present. So in that case, that is also there. I have mentioned here. Says contractual work. In another case also, there is a contractual obligation in the state of Kerala High Court. They also passed the order, and regarding implementation of the Article 226 on delay in filing an application, the High Court in reference even after period of expiry of the limitation prescribed. At page number, Sri Vallabh Glass Works Limited and Unauthorised Union of India, reported in 1984, 3 SCC, at page number 119, at page number 118. The Supreme Court decision.
See, Mr. Sahu, this is your written argument.
Yes, yes. All the written for I filed all
Yes,
my argument
with all the authorities.
Yes.
Just now, so I found difficult. When you refer to any case here, specific paragraph are not mentioned. So now.
Yes, I have quoted here.
Now.
No, my lord, here.
Where have you quoted?
I have mentioned at page number. At page number 9. In my compilation written argument, page number 9, and I also mentioned the page number where that is. I mentioned here 7 cases citations.
No, but citation, the specific paragraphs.
Yes.
Not here.
Page number I mentioned.
No page number, but you see. I'm just giving you an example.
Yes, yes.
One case may run into 30 page. It may run into 60 paragraphs. So you can't expect me to read all, in spite of the fact that you've given such a voluminous compilation.
Yes.
It would be better, at least mark your.
Yes, actually that is also marked, my lord. You can see in page number 5, paragraph 2. That is also marked. Is argument number 2, written argument, refer para number 17 or para, para 22.
Here is marked, no doubt. Here is marked. So all these are reflected in this page 9.
Yes. In argument 3 also, para number 9 and para number 4 in except for ABL International, that is this covers a whole. This covers a whole ABL International.
This page 6 is Bhom Singh.
Yes.
You have got
Bhom Singh. That is also same case.
No paragraph.
No paragraph. Actually, it's
ABL, so no paragraph.
At page number 120, start 120 to 123.
See, your written argument is almost a writ petition in itself.
Actually, what was last year, I compiled all these things and files for easy reference file.
Okay. So, Mr. Shulai, have you filed your written argument?
No, Your Lordship. Only thing is, Lordship, there is no thing on record to show that there is a handing and taking possession, Your Lordship. There is no completion certificate, Your Lordship. Annex in the writ petition, Your Lordship.
It is actually final bill. It is their responsibility.
Have you
My lord.
raised- have you
After
raised that in
completion
your-
of final
How
bill, they
can,
will
how
fix-
can the final bill be done if,
my lord, if
if
that
there
is
is
the
no
situation,
completion certificate? There is no handing over, there is no taking over possession, there is no completion certificate enclosed in the writ petition, Your Lordship.
My lord, here actually they have received and they used for the public purpose. When once they have accepted this project, it is by implication they have accepted, and that is be public use.
See, that could be so.
Final bill they have not prepared.
That could be so. But
Yes.
you see, I think the formal procedure has to be followed.
Yes.
There has to be handing over, taking over. See,
That is their respect.
for example,
Yes.
from my experience, there are many buildings, or even in court buildings, where the building is already completed and occupied, but that handing over and taking over has not yet taken place. At you see, at some point of time, that has to be done.
Yes.
That has to be done.
To regularize all this is that
Regularize.
is yes.
So-
To regularize all this
So
is
that
they
you
have
see,
to do.
what the learned AG has said is valid.
Yes.
See, until and unless that is done formally, how would you know on record that is completed?
Once I have handed over, they come to the notice of the department.
Yes.
They have to complete all these
But you have
procedures,
not
formalities.
but you have not handed over.
No, I have handed over.
He says no.
I have no. Just let me file by affidavit.
There must be a
Let me
certificate.
file
There
by
must be.
affidavit. I have
There
no
must
objection,
be
my lord. If they have
taking
not
over
taken
and,
over by this project, how
handing
they
and taking
used
over,
in the
Your
road
Lordship.
last 10 years, that is in the public use, and
I'm
they
not
are
saying-
keeping silent. My grievance is that.
See, more often than not, that is the practice. That is the practice. Completed use.
Yes.
See,
And I have handed over. This is not a small thing I can keep in my bag. So I handed over to the department. They completed, they accepted, but formally they are not doing.
But where's your communication?
Yes.
Where's that communication that this is completed to so and so? This is completed.
Yes, I that has been intimated.
Where is it?
Yes. इंटीमेशन हुआ है ना, जो हम लोग कंप्लीशन करने का बाद इंटीमेशन हुआ है. देखो है, there is intimation that I have completed and
Exactly.
yes,
Where is it?
that is there.
I did not see anything.
देखो चेक करो है. No. Actually, that has been intimated. I am giving somewhere it is mentioned that has been intimated, and during their environment also they have not raised this issue. Yes, I'm trying to verify, locate this where on that date which has been handed
It
over.
has to be from your government's.
Yes,
your
yes,
petition.
that is there. That is there. I have intimated. लेटर ऑफ इंटीमेशन है भाई 24. नहीं उसमें भी है. अब यहाँ लोग लगाया नहीं है. नॉन रजिस्टर पेमेंट. है मेंशन है.
In fact, you see, Mr. Sahu, that narration should have been, you see, in your petition,
yes,
in the first few paragraphs.
Yeah.
That this is the work, this is the contract.
Yes.
We have done, we have completed the work. This is the intimation or completion certificate, and then your demand.
Yes.
But
that is there.
It's not here.
Actually, somewhere that has been there. At this time I am unable to locate this. But his time and again, name of the revised estimate extensions are available.
It has to be in your pleadings. It has to be in your pleadings.
Yes. And so I should relocate where on which date that has correspondence made. But there is no averment in also their petition that is it.
See, they cannot reply to a non-existent averment.
Yes.
First, you have to state your case, then they will reply.
Yes.
He has pointed out because these are vital.
Yes.
It is a vital.
So that can I will trace out. So I will trace and submit the next date. Actually, I am unable to trace at this point because so many documents are there.
Fine. So we'll take it up after vacation.
Yes, that can be done. I will take. और चिट्ठी मिले correspondence है देखो
council
कहीं ही मिल जाएगा.
Also heard Mr. Anishulai Leonard AG along with Ms. Artoni. Matter has been heard substantially and will, however, is not concluded today. The argument will continue on the next date fix. As agreed to by the parties, this is matter after 2 weeks.
Apply your launch.
Item number 8.
Yes.
It's same, your lord. Same issue, your lord.
Here in this case, my lord, what is the non-payment by this? Here there is a completion certificate. Handing over of the project, there is a completion certificate. That is there.
We'll take up the matter on
Together.
28. This is matter after, as agreed to by the parties, this is matter after 2 weeks.
Apply your lordship.
Item number 9. Item number 13.
It is Your Lordship. Your Lordship, Master Ben is supposed to join through VC, but at the moment he is on his legs before the Honorable Court, Ethan Garben. So, Your Lordship, I can repeat that this matter come up on Friday, Your Lordship. I'm sorry for the inconveniences, Your Lordship.
My Lord, this matter, in the previous court, my Lord, court room number 4, my Lord, this matter was heard. This matter, this matter was finally heard, my Lord, from the appellant side on 13/6/2025 this year. And thereafter, my Lord, written argument was also submitted from the appellant side. This matter was awaited for submission of the written argument from the state and also hearing from the state side, my Lord. But this has to be heard again, my Lord. So therefore, my Lord, I pray this matter will come after vacation, my Lord.
Stop joking.
Your Lordship,
So, my Lord, I'm praying that this matter may come after vacation.
Your Lordship, as per Mr. POB instruction, he requests to list this matter on Friday, Your Lordship.
That is not the way, my Lord. Kindly look at the orders in.
Because if you see, the matter has to be heard again, then.
It is to be heard again, but it cannot be existed on Friday.
24. We'll take it out after vacation. On premier by Mr. R. Gurung Lanerji. This is matter after vacation. Take it out.
14 is connected, right?
14 connect.
It's connected.
Same order.
Any mention?
May I please, Lordship? I beg to mention item number 6, Lordship. I'm praying for 4 weeks' time, Lordship, in this matter. Because in this case, Lordship, there are two convicts. So one has preferred the appeal, the other is left out. So to the other one, communication was made that he has also a right to file an appeal, and he has a right to be heard. So therefore, he is taking time that he will communicate the things to the family member. If the family member chose to appoint a private counsel, the private counsel will file. Otherwise, the illegal aid. So 4 weeks' time, Lordship.
On pre-made by Mr. S.D. Upadhyay, the legal aid counsel, that is adjourned. List is after 4 weeks.
Please. I beg to mention item number 7, Lordship. 7, I have some difficulty today, Lordship. No. Objection.
Pre-made by Mr. S.C. Sheikh, Leonard G. This is matter up to 4 weeks.
Please, Lordship. Lordship, I beg to mention item number 5. I pray that this matter may be come up after 3 weeks, Your Lordship.
On pre-made by Mr. Leonard Counsel of the Assembly, this is matter up to 3 weeks.
Highly obliged.
Obliged.
Supplementary list, item number 1.
May it please, Your Lordship. The Lordship will recollect these are the cases relating to the appointment of 3 judicial magistrates in the District Council from the waiting list. Now, Your Lordship, by the judgment, I'll only draw Your Lordships to the last part of the judgment, page 45. This court has directed that one supernumerary post be created. Page 45.
Yes.
Second paragraph. A silver lining in the sky occurred during the close of hearing of this appeal when learned Deputy Solicitor General remarked that there was existing one vacancy and one future vacancy to arise soon. Taking into account these submissions, we direct that to have a fair and just result, the clock should be put back where it was when the 3 posts were filled up from the waiting list. This could be done by creation of one supernumerary post. There should be no difficulty in this because the Council has repeatedly urged that it was in need of more judicial officers to dispose of pending cases. Hence, we direct the Council and the State to create one supernumerary post. Any approval from the High Court or the Government is deemed to have been obtained. Such supernumerary post should be created by 30th September 2025. Thereafter, a selection to fill up these posts should be carried out where the appellant is at liberty to participate and to be concluded within a further period of 3 months. In this way, the grievance of the appellant is also redressed. Now, my Lord, according to my understanding, a supernumerary post is a temporary post. It is created to absorb someone just for a time being, temporarily. Now, my Lord, if we create a supernumerary post, and then call for selection, that will not be permissible, my Lord. Because supernumerary posts, as the definition, I've done a lot of research, my Lord, on this part. This from the Department of Personnel Training and Government of India. What are supernumerary posts? The following principles, my Lord has got it?
Yes.
The following principles, page 5, I've marked, should be observed while creating supernumerary posts under Rule 11.2. The supernumerary post is a shadow post, that is, no duties are attached to such a post. The officer whose lien is maintained against such a post performs duties in some other vacant post, and accordingly it should not be created in circumstances which at the time of the creation of the post or thereafter would lead to an excess of working strength. As a supernumerary post is a post created for accommodating a permanent officer till he is absorbed substantively in a regular permanent post, it should not be created for an indefinite period or other permanent posts. but should be created for a definite and fixed period sufficient for the purpose in view. It is personal to the officer for whom it is created, and no other officer can be appointed against such a post. It stands abolished as soon as the officer for whom it was created vacates it on account of retirement or confirmation in another permanent post, or for any other reason. In other words, no officiating arrangements can be made against such a post. Since a supernumerary post is not a working post, the number of working posts in a cadre will continue to be regulated. That is, if a permanent incumbent of one of the regular posts returns to the cadre and all the posts are manned, one of the officers of the cadre will have to make room for him. He should not be shown against a supernumerary post. No extra financial commitment is involved in the creation of such a post in the shape of increased pay and allowances, pensionary benefits, etc. Administrative authorities should maintain a record of supernumerary posts, the particulars of the individuals who hold liens against them, and progressive abolition of such posts, as and when the holders of the post retire or are observed in a regular permanent post for the purpose of verification of services for pension. Now, my lord, in the district council, there are already 6 judicial officers, magistrates, subordinate district council code. And there's one post also which is still vacant. My lord, we don't need any more, in fact, judicial officers. The 3 were absorbed from the waiting list. Now 1 post is available and 1 post of additional judges also being looked into. My lord, what
the cadre strength has been fulfilled. All the cadre strength has been fulfilled.
Yes. So, my lord, we are reviewing only against this direction, against creation of a supernumerary post.
Mr. Dindo, I don't think you have a case for review. Appeal, maybe.
Well, my lord, supernumerary post, how can we creating
exactly?
Yes.
But that is the decision of the court. Yes. If you agree by it, you appeal. It's not a question of of something wrong with the decision itself.
Something wrong. What I'm trying to say is that maybe when this court said that you should create a supernumerary post,
we understand.
Yes.
We understand whatever you have said.
Yes.
You may. You see, we're not saying that you don't have a cause or you don't have a case, yes. But I don't think this is a proper forum. What do you say, Mr.
Lordship, so what the role of the state is concerned, Your Lordship?
But you have
you don't have the role, Your Lordship.
Let notice go,
Mr. Dindo, I think you should pursue other avenues. Where is the area of parties?
Let notice be issued, my lord, to the other to the party, the appellant. Let's see what they have to say. Because primarily, my lord, is only on that point you're filing this review petition.
What will they say? These respondents that you have read, 4, 5, 6.
My lord, has held the single judge decision. I mean, retaining them in service.
Yes.
But the district council is only in respect of the 1 post.
The state has got no role here.
No, the state. Direction was given to the state also, but actually the state has no role.
State has no role.
Okay, we'll hear you all. But Mr. T.K. Dindo, Senior Counsel for the review petitioner. Who has submitted that the order of this court in passed in WA number 51 of 2020. The order dated the judgment dated 19/8/2025 passed in. Particularly
page 45.
Para
Page 45, Mal.
Third paragraph from the bottom.
Page 45.
particularly page 9 of 10 of the said judgment at the second, third and fourth para of the same requires consideration for review. However, at this juncture, the learned senior counsel has submitted that notice may be issued upon the respondents number 1, 3, 4, 5 and 6, comma, the respondent number 2, State of Meghalaya, being duly represented by Mr. Indishalai, Leonard AG. Accordingly, let notice be issued. One such respondents, the same returnable within 2 weeks. This is the matter thereafter.
Oblige, Lord.
And they release item number 1.